Here's a great question, and again, it's about foreclosure. So you can tell this foreclosures are kind of starting to pick up again because I'm starting to get more questions about it. If a home goes into foreclosure and two people are on the deed, but only one of them is on the loan, does the mortgage company have to sue both of them in the foreclosure proceeding? And the answer is yes. Remember, we talked about it last week. Foreclosure is about two things: title and debt. Two people are on the title, so the mortgage company has to foreclose out both of their interests. You see it a lot with a husband and wife. They'll come in and say, oh, we got to file bankruptcy. We need to get, we need to hold up this foreclosure and work out a deal. And I look at it and say, well, they're both on title, but only one person signed the note. So if that one person, both of them wanted to file bankruptcy because they thought they were both obligated on the debt, no, not really. If you have to file bankruptcy, only one person has to file. And that tells me, talking to these people, that they haven't looked at their credit report in years, at least since they bought the house, because they would have known that it wasn't on the one person's credit report. The mortgage company can't put anything on the credit report because that person's not legally obligated to pay the debt. So how can they report negatively or positively about that person when that person's not legally obligated to pay the debt? Kind of interesting. I see everything happen, but that's the way it works. So the answer is no. Part two of the question, are they able to come after the non-responsible person for the money? Great question. The answer is no. In a foreclosure proceeding, the judgment, if it gets all the way through and they get a judgment, the judge can't issue a money judgment against a person who's not on the note. The money judgment, can only be against the person who signed the promissory note. The judgment is going to be multi-part, and it's going to say that they're going to foreclose out party one, their legal ownership interest. They're going to foreclose out party two, legal ownership interest. Then they're going to say there's no judgment for money against party one because they didn't sign the promissory note, but there is a money judgment against party two because they signed the promissory note and they owe the debt. So that whatever debt's remaining, let's say there's a deficiency of $15,000. Party two is going to be legally responsible to pay that money back, or, if they can, but party one will not be legally responsible to pay that debt because they never signed that promissory note. So it's something to think about, folks. If you're thinking about getting into a mortgage with your wife, do you both have to sign this debt or not? Do you both have to sign this application to buy the car or the promissory note to buy the car or not? Should we get a joint credit card, or should I keep the credit card separate? Wife's in her name, mine in my name. You know what I mean? You go to Best Buy and you want to buy a TV. We had a question about a $2,000 TV. Do you buy it jointly or do you buy it in your own individual name? And I've seen it all ways. I'm always a big believer in keep the assets together, but the debts separate. And that all comes down to issues we've talked about in the past about tenancy by the entireties. That's a great exemption because Florida recognizes a husband, recognizes a wife, and it recognizes the marriage as an entity that can own assets. And those assets are protected from individual creditors' claims. In other words, let's say my wife and I own a car as tenants by the entireties, and I have a judgment creditor. A creditor says I owe them $10,000. They sue me to get a judgment. Can they touch that $10,000 car because of my debt? And the answer is no. That's a marital asset. They can't touch it because it's not my individual asset. It's owned by the marriage. So that's something to think about in your financial planning. And I know I'm going to get a lot of questions about this, and we've talked about it on the show. We should probably keep a little segment on it every couple of weeks so that we know what we're dealing with. Okay, so that's the answer to that question. And it says, if the lender mortgage company isn't allowed to do any of the above, what recourse they have against pursuing him? The bottom line is, I think we've talked about that. The final judgment can only give relief, what relief that creditor can have. In other words, a judge can't give a judgment against a party who's not on the promissory note, or a money judgment against a party who's not on the promissory note. So the only relief that they can seek is what they're legally, what they can claim is what is legal. That's why I always want you to look at if you do get served with a foreclosure complaint, I definitely want you to see an attorney as quickly as possible to determine these legal rights and remedies. Some people come to see us, they don't need to file the bankruptcy, they don't need to fight the foreclosure, they just need to walk away from it. Or some people come to see us, they need to go into a short sale. But those will be determined when you meet with the attorney.